In the next series of lectures, we're going to talk a little bit about the criminal justice system and the civil justice system, and particularly our court system that we have in this country. Let's start by talking about the criminal courts. Most of you are very familiar with the criminal courts, but there are some things that you may not realize that's unique to us. For example, the type of court system that we have in this country is called an adversarial system. And it's based on the English common law system. In other words, we borrowed pretty heavily from what the English were doing when we started our own country. The adversarial system is very familiar to you. What you have in the court system is one side and the other side. You have two sides. You have a prosecution, you have a defense, and they fight it out and we come up with a verdict. This is what you're mostly used to. I just want to compare that to the other type of system that's called the inquisitorial system. You'll see the inquisitorial system, even though England has the adversarial system like we do, most of the rest of Europe has an inquisitorial system. An inquisitorial system is quite different from what we're used to. First of all, the person who makes the decision, guilt or innocence, is a judge or a panel of judges. So there's not really two sides. In an inquisitorial system, it's assumed that every single witness that is going to present evidence in court is going to be neutral and is going to be providing the court information. The witnesses are there to inform the judge. They're not there to participate on either side. If an expert witness is called, the expert witness is called by the court to provide some information. The expert witness is not for one side or the other. The other interesting thing about the inquisitorial system, which by the way many Asian countries also have, you're presumed guilty until proven innocent. So the idea here is that why in the world would the police and the state bring any charges against you unless it thinks you're guilty? So the evidence then has to try to prove that the state made a mistake and you are in fact innocent. So going back to our adversarial system, you have two versions of the truth that are presented. The prosecution presents what they think is the truth. The defense presents what they think is the truth. And in an adversarial system, the fact finder sorts it out. In other words, the fact finder listens to the two sides and then determines the verdict. And of course, as you might guess, the fact finder is who? It's the jury. Yes. So we borrowed very heavily from English common law. England is one of the few countries like us that has an adversarial system. But that it would be a mistake to suggest that we're exactly like the English system. Let's compare ourselves a little bit with the English system. First of all, the English system is divided into two sorts of types of court cases. For example, attorneys are often called solicitors or barristers. So as an attorney, you may be a solicitor or you might be a barrister. Solicitors are they're kind of lower level attorneys, and they deal with lower level issues such as they'll deal with wills, they'll deal with divorces, any kind of contract law. Barristers, on the other hand, are the attorneys that you're going to see in the high court. They often wear the white wigs, still traditional in England, and it's called they'll probably present their case at the Crown Court. So let me just show you a short video that gives you a little bit of an idea of what this Crown Court looks like. And as you can tell, it's very different from what we experience here in the United States.
I am the judge, and it's my job to interpret and uphold the law. Other people present during a trial at the Crown Court are the prosecution barrister and the defence barrister, usually with solicitors behind them taking notes, and the jury. The defendant will sit in the dock and be present during the trial. It is at my discretion whether or not there is a public gallery. After the jury has been sworn in, I address them directly. I inform them that it is for them to decide if the evidence they are going to hear proves the defendant's guilt. I also inform them that it is their job to consider the evidence, not the law, and that I will guide them if necessary on points of law.
I am the next person to address the jury. I introduce myself and explain that I appear on behalf of the prosecution in this case, and my learned friend, who I name, appears on behalf of the defense. I then outline the prosecution case, explaining each offense and the evidence the jury will hear in proving this. I will state that it is the prosecution's responsibility to prove beyond any reasonable doubt that the defendant is guilty of the offense that they are before the court for. I will introduce the first prosecution witness. I will then ask a series of questions with regards to the evidence they have given in a statement to the police. This is known as examination in chief. Upon completion of this, the defense may ask the witness a series of questions. This is known as cross-examination. Upon completion of the cross-examination, I may be given the opportunity to ask a further series of questions to the witness. This is known as re-examination. I will continue to call witnesses until all the witnesses have been called to the stand. I will announce to the court that this is the case for the prosecution.
At this point in the case, I may make an application of no case to answer to the judge, stating that the prosecution has not raised sufficient evidence to prove that the defendant has committed the alleged offence. If he finds in favour of my application, he will instruct the jury to find the defendant not guilty, and then he will release the defendant. This is an acquittal. If the judge considers the prosecution has raised enough evidence, then I will continue with my case. As with the prosecution barrister, I will introduce the witnesses. However, at this time, they will be giving evidence for the defence. This will follow in the same procedure of examination in chief, cross-examination, and then re-examination. At the end, I will declare that was the case for the defence.
I then stand and give what is called my closing speech, where I outline the prosecution case and try to persuade the jury that the defendant is in fact guilty.
I then stand and give my closing speech, outlining the defence's case and trying to persuade the jury that the defendant is not guilty.
I will then sum up all the evidence. I will direct the jury on the legal issues and what the prosecution has to prove if they are to find the defendant guilty. I will give them the legal options available, reminding them that if they are not sure, they must find the defendant not guilty.
We then retire to make our decision. Once a decision has been reached, we return, and as foreperson of the jury, I announce the jury's verdict. If found not guilty, the defendant is released.
If the defendant is found guilty, I will make a statement in mitigation to the judge. The judge will take this statement into account before sentencing.
I thank the jury for the service that they have provided. If the defendant is found not guilty, I will release the jury from the court. If the defendant is found guilty, I will move to sentence him in a straightforward case. It is likely in that instance that the jury will remain in court. I may, however, postpone sentencing where other factors are to be considered. This can be particularly appropriate where there have been contentious issues or where the defendant's background is likely to have a significant impact on the sentence I pass.
As you can see, there are lots of similarities in that courtroom between what you'd expect in an American court. However, you can see there's lots of inconsistencies as well. You see the standard of proof is beyond a reasonable doubt, just like ours, but you can see that it's a much more formal procedure with the wigs and the robes and so forth and so on. Another interesting difference between the English and U.S. system is the difference between defense and prosecuting attorneys. You saw in that Crown Court, there is both a defense and a prosecuting attorney. But what's interesting in England, and by the way, that's changing a little bit now, but at least right now it's still true, attorneys or barristers, will put their name in a pool, and whenever a case comes up, let's say there's a murder case, the Crown could ask any attorney to be a prosecuting attorney, and then they might be asked to be a defense attorney on a different case. In other words, attorneys are not prosecutors or defense attorneys, they may play a role in different roles in different cases. As you might guess, what that does is it makes them more able to see both sides of the issue, since they might have been a defense barrister in one case and a prosecuting barrister in another. It's expected that whichever side asks you first, if you have the time and you're available, you're supposed to say yes. So there isn't that demarcation that we have here in the US. Another interesting difference between England and the US, in the United States, the prosecuting attorney, the DA, decides whether or not to take a case into prosecution. In England, it's the police that initiate the prosecution. And that makes it kind of interesting because a lot of police officers in this country, you know, they'll often talk about the fact that they feel like they put a lot of work into a case, they build a case, they send it to the prosecutor, and the prosecutor decides not to prosecute. And they feel like all of their work went to naught. In the English system, it's quite different because the police are the ones that make that decision actually and decide whether or not there's enough evidence for prosecution. So you can tell that although our courts are very similar, there's also some differences. Finally, I'm just going to show you a very short part of this particular video, and this is the lower court. So I just want to show you that, you know, the Crown Court, which is the higher court, there is a lower court that deals with other kinds of issues. And again, I probably won't show all of this to you.
We are the magistrates. We hear all the evidence in the case and decide whether the defendant is guilty or not guilty. It's for the prosecution to prove their case beyond all reasonable doubt, otherwise we will dismiss it. Traditionally, there are 3 magistrates. I am the chair and will decide the case with my 2 colleagues. If my 2 colleagues can't agree, I will have the deciding vote. Occasionally, we may have to sit as a pair and then decide the case between us. Although we've had some training, we are not legal professionals and we are not paid.
Magistrates hear all summary offences within their jurisdiction. We can also hear triable either way offences where the defendant has agreed that this can be the case. If we believe that a trial is too serious, we can refer that case up to the Crown Court. Even after we've heard a case, we can refer that case to the Crown Court if we believe that our sentencing powers are not sufficient.
I am the legal advisor to the justices, although you may still hear me referred to as the clerk of the court or the magistrate's clerk, and I am legally trained. My job is to ensure that everything runs properly and that all the proper procedures are followed. I will ask a defendant to enter a plea, and I will ask witnesses to identify themselves. I will advise the magistrates on legal matters, and I will ensure that only admissible evidence is put before the court. If a defendant is unrepresented, I will advise them to ensure they get a fair trial.
I am the usher. I ensure that all witnesses have answered their summons. I'll fetch witnesses in when they're called and administer the oath or affirmation. When the witness is giving evidence, I will pass exhibits around the court. I can even fetch a glass of water for someone if they're thirsty. You will hear me say, "All rise."
I'm the prosecuting solicitor and I present the prosecution case. There are 3 things that I must prove to the satisfaction of the court. Firstly, that an offence has been committed. Secondly, that the defendant has committed the offence. And lastly, that all the evidence has been gathered in accordance with the correct evidence gathering procedures. If I fail to do any of those things, then the defendant is entitled to an acquittal. I will ask questions of prosecution witnesses to enable them to give evidence. I cannot ask leading questions or suggest answers. Obviously, I can only present evidence that has been gathered fairly. If there is a case to answer, and the defence call witnesses, then I can cross-examine those witnesses. Remember that prosecutors are only as good as the evidence they are given.
I am the defence solicitor
my role to protect the interests of my client. I can challenge evidence that has not been gathered fairly in accordance with the Police and Criminal Evidence Act of 1984 and have that evidence excluded if so required. If you've been fair, thorough, exercised your powers correctly and can account adequately for all your actions, then there should be little for me to challenge.
Okay, that gives you a very good idea of what the magistrate court looks like. You can see that it's quite different. The solicitors are the attorneys in this particular case, but I think the most important difference is that you actually don't have a jury trial at this level. What you have is something that's more like an inquisitorial system, where you have these three judges. Although they're not legally trained, you have these three people making the decision about guilt and innocence. And so you can see that the English system is quite different from ours. In some ways it's similar, but in many ways it's quite different from ours. So anyway, this gives you a little bit of a flavor of how it's different in different countries. But let's come back to the United States again. Let's talk about crime and what that means in the United States. One of the things that's really important to know is that a crime is an offense against the state. I realize that most of us think a crime is against a person, a victim. There's a person who was hurt, who is victimized. This is the case of the state of Wyoming versus Aaron James McKinney, and he was one of the defendants in the Matthew Shepard's murder. Now, although we know that Matthew Shepard was the victim, once the crime goes to the court system, the victim kind of becomes invisible. And this is something we're going to talk about a little bit later on. Because all crimes are against the state, not against a victim. And of course, if you commit a federal crime, it's against the nation. But the important part to remember is that the victim isn't really even named in the criminal case. As you can see here, you have the defendant's name, but the crime is against the state of Wyoming. And importantly, only the state can punish the victim, the defendant. So a crime then is considered a class, a behavior that you engaged in that violated something, a state statute. Okay? We're going to talk more about this later, but let's just quickly shift gears for a second and talk about civil courts. Now, we're not going to spend a whole lot of time on civil courts, but they are quite different from criminal courts. Obviously, the big difference is that this is a dispute between private individuals. This is not, Norina Nunez versus the state of Wyoming. This is Norina Nunez versus John Smith. And even though we think of criminal case, most of the television shows focus on criminal cases, civil cases far outnumber criminal cases in this country. In fact, they're quite common. They're the most common type of case in this country. So let's take a little bit of a look at civil cases. What's the difference between civil system and the criminal system? First of all, if you're going to sue someone in the civil system, you have to have what's called standing. A litigant is somebody who is making the suit or suing someone. What does it mean to have standing? Have standing means that you have to have personally suffered because of someone else's behavior. So for example, suppose I think that certain cigarette companies are trying to advertise to get kids to use cigarettes. And I feel that's totally outrageous. I'm really upset because I know that cigarettes are the #1 cause of cancer, and I worry about the health risks. And so I want to sue the tobacco companies because of some of their advertising. Well, the problem is that the courts will say that I don't have standing. I have not been personally injured by the tobacco companies, so I don't have the standing to sue them, even though I think their behavior might be outrageous or morally wrong. So in order to sue someone, you have to have standing. Another difference between the criminal courts and the civil courts is the standard of proof. As you know, in the criminal court system, the standard of proof is beyond a reasonable doubt. And in the civil system, it's preponderance of evidence, which simply means if the evidence is 50-50, then you don't have a preponderance of evidence. But if one side is 51% correct, then you have a preponderance. So just 51%. It's a much lower bar than beyond a reasonable doubt. Also, finally, in a civil system, due process is not as extensive. You do not have the right to an attorney. If you want an attorney, you're going to have to pay for the attorney yourself. And this is one of the reasons why in our civil court system, sometimes the litigant that has the deeper pockets can often win because they can afford attorneys and they squeeze out the little guy. So how do you file a civil suit? First of all, the plaintiff, that's the person who initiates the suit. The defendant is the person who responds to the suit or is being sued. So you have a plaintiff and you have a defendant. The plaintiff files a complaint in the proper court. This is easier than it sounds. The proper court means who is responsible for whatever it is that your complaint is. So for example, if you're a tenant and you have a complaint against a landlord who has not repaired anything and now things are falling apart and you want to sue them, you have to figure out within your city which is the proper court to file that complaint. And it can be more difficult than it sounds. The court, once they hear the complaint, they'll determine where that complaint is going to be tried, which jurisdiction and where the complaint is going to be tried. Obviously, if I'm in Laramie, Wyoming, and I have a tenant complaint against my landlord, the court will determine that the venue and the jurisdiction should be here in Laramie. However, you can see where you have a class action suit, for example, where there are lots of plaintiffs against a defendant. And this was true, for example, when the lawsuit against the tobacco companies many, many years ago. There was a question about where the trial should be held. As you might guess, the tobacco companies very much wanted to make sure that the trial was held in tobacco country, like North Carolina, South Carolina, Kentucky, places where tobacco was grown, because then jurors would be drawn from those communities and they'd be much more sympathetic to the tobacco companies. Obviously, the other side wanted to keep the venue out of tobacco companies or tobacco states. So you can see where venue might be a very big deal for civil suits where you're trying to draw a jury that might be sympathetic to your own point of view. So the court determines the jurisdiction and the venue, and then finally serves the summons to the defendant. And I'm not going to go into much more detail than this because, to be honest with you, there are lots and lots of steps in a civil trial, and that it's not going to really be the focus of this class. So just giving you a flavor of how this particular thing works. Quite different from a criminal case where you have the police initiating the investigation, the prosecutor deciding whether or not to try the case, and venue and those kinds of things are only important if there's a lot of pretrial publicity. Okay, so switching gears just a little bit, just to give you another little flavor here. In the United States, and I'm moving back sort of to criminal cases, but this is also true of civil suits. Whenever a case is heard, a judge decides or a jury decides the verdict, but we have the opportunity to appeal a case, and that's true for civil and criminal appeals. And the United States has a system. It's the U.S. Courts of Appeal. We have a process for appealing cases, and we have a place where appealed cases go. So here is the appeals court system in the United States. As you can see, it divides the country into 13 different appeals courts. There are 1 through 11 that take care of all the states. Then there's the D.C. Appeals Court, because obviously D.C. is not a state. And then there's a federal appeals court. What that means is that when an appeal comes from any one of these states, so for example, here is Wyoming. We're in the 10th district, okay? That means that any case that's appealed out of Colorado, Kansas, New Mexico, Oklahoma, Utah, or Wyoming, anything that's appealed goes to the 10th district. And so they will hear the appeals for those states. The reason why I think this is interesting and important is, some of you may not realize this, is that these courts do not always agree, okay? And we see this over and over. And so the 10th District court may go one way, and let's say the 5th District Court goes another. And when there's a conflict, probably it will go to the Supreme Court, because the Supreme Court will have to sort it out. But importantly also is something that gets decided by this court. Give you an example. Utah had a same-sex marriage case that was appealed to the Court of Appeals. The court decided that same-sex marriage was legal. And when they decided that about this Utah case, it automatically meant that it was legal in every single one of the other states that it had jurisdiction over. So that's how Wyoming legalized same-sex marriage. It was because the appeals court decided that Utah case, and it meant that that was the law of the land in all the states it has jurisdiction over. So that's just something interesting to note and keep in mind. Okay, so I've talked about 2 different kinds of courts, the criminal courts and the civil courts, but there are other courts as well, and we're not going to spend as much time on them as we will on some of the others, but let me just mention them real quickly. Okay, in the United States, there are also what we call family courts. Each state has, some states have juvenile courts and family courts separate. We kind of combine them too. So the juvenile family courts, that's one type of family court. And then there's a domestic relations court. That's another type of family court. Let's take a little bit of a closer look at the 2 of them. So the juvenile or family court. The main purpose of the juvenile family court is to protect children and preserve families. So this is not a court that punishes people. People who go into this court have not committed a crime. This is more like a civil process, not a criminal process. But you'll see Department of Family Services, when they have to initiate a case against a parent because of child abuse, it'll go through this court. If a juvenile commits a crime but is going through juvenile court, they'll go through this court. The main purpose of this court is rehabilitation, not punishment. Also, the people who initiate these cases, it's not the prosecutor. Typically, these cases are initiated by social services. Although you'll see that in the state of Wyoming, prosecutors are often very involved in deciding whether or not to go to this court or not. The other family court is the domestic relations court. And this particular court is involved only in things like divorce and child custody proceedings. These cases are initiated by parents. So we don't have social services, we don't have police, we don't have district attorney. A parent is the one who initiates this particular case. So if couples want to have a divorce or want to determine custody of their children, they initiate the case in this court. Very few due process rights. The parents, if they want an attorney, they have to hire their own. This court also has very little enforcement power. It doesn't have the power of the police or social services or anything like that. It has to rely on the people involved in the court to follow through on those orders. Okay, so I've given you just a little bit of a flavor of our criminal and civil courts in this country, and we'll continue this discussion by looking at sort of the judicial issues, judges, how they work, what some of the issues are with judges next time. Thank you.